disability, and believe you me, we can do this 20 years from now. It will always generate a lot of debates. And it doesn't help in some instances, some countries, because of backgrounds, cultures, and so on, they don't treat certain disabilities as disabilities. So the best we could do was to come up with a definition that was then later linked to the articles of the protocol in terms of the issue that you raised of people with albinism. So they are definitely part of the disability movement, and unlike in some countries where they say they are not disabled, but we believe that they are part of the definition that is there in the protocol. I would just say briefly about, my colleague Tom will answer the issue from Gambia, but about the issue of why AU instruments are not being implemented. Sometimes we are to blame as Africans. I have to be honest with you. We heard in Rwanda that 55% of AU protocols are ratified. 55%. There are some protocols from way back that have still not been ratified. I think it's high time we started prioritizing what is African, and to make sure that we put it at the center of planning. And the very fact that we rushed to sign the UN Convention on the Rights of People with Disabilities when it first was opened. And yet now we have the protocol which has been around for a year. So we have our own problems as Africans, to be honest with you, and we need to deal with them.
Thank you very much, Eke. I think for the case of Gambia and I know a good part of West Africa, it's all about responsibility and our countries planning well. If you were to drive out of this Pan-African Parliament to Lesotho and a good number of African countries where even the World Bank has said these countries are poor, you cannot plan and have support social security systems for your citizens. And they went ahead and did it, which explains that, and as also elaborated by my colleague Lefoko earlier on the protocol to social protection and social security, it is possible for our countries to plan and provide safety nets to our citizens. You don't see people begging out here on the streets outside Pan-African Parliament, as you would see in some of our other capitals, simply because there is some sort of, even if it means minimum grant systems. But most of all, and that's why I think as legal practitioners, I think it's not real for us to criminalize poverty. We know begging in a good number of countries is criminalized. And we are asking, is this the progressive way? Definitely not. And there's a lot that's taking place within the human rights defenders movement in West Africa. And we know our good friend Ibrahim Debassi in Gambia, and during the different sessions in the Gambian Commission, we have seen quite a good tectonic shift in terms of creating awareness and even going to court. We know the first communications to the Gambia Commission was the well-known case of Perret and the Gambia, and we know the commissioners did give good decision on that. Thank you.
Okay, my point of view is just with regard to Mr. Dube's contribution, that albinism, I think it's with issues that certain country does not recognize it as a disability. Maybe my Namibian point of view is that there we look at it as a disability, so automatically it's provided for within the disability framework, because we believe that if you have specific laws for each and every disability, you are never going to finish, because new ones are going to keep coming up. So rather just provide them adequately, and within your regulations of your laws, that's where maybe, or directives, you go in detail. By adding their sunscreen on the essential medical list, providing them grants just the same way you provide persons with disability, and perhaps ensuring that in schools they specific that they need big print. That's it. You don't need a specific law, because we believe specific law will create more discrimination than solving the problem. With regard to whether we have enough self-esteem or not, that is not the question. The question is, does society see us as part of the human class or part of the animal class? Because I think what we have learned in Africa is that once you have a disability, you are no longer relevant. And then everybody dumps you there. But then what I always say is that you don't know what tomorrow holds. Today you dump me, tomorrow you join me.
Thank you so much.
I wanted just to say one point. Let me just maybe just say one thing within a minute, to say that the whole issue of vulnerable groups, you can take the example of, let me just take the example of this country. You will still be fighting the issue of discrimination on the basis of color and all that, because the whole issue is about power. It's all about their orientation, about our culture. I'm just making it simpler for me. And the whole issue about vulnerable groups in Africa is that as soon as we speak about vulnerable groups, we speak about them and us. And when we speak of, as African Union Commission, that I represent here, is that we come up with these frameworks, whether legal or policy, for you now to implement and find the effectiveness. Because whether we like it or not, the disparity between the haves and the have-nots in Africa is increasing. There is evidence to that. Economics have found it. Even legally, if you look at persons with disability, accessibility to justice is a serious issue in all the countries that I can think of. And that is why even in employment, whether as a legal counsel for parliaments and all that, you see the percentages are showing that still those who holding power, those holding building barriers, coming from environments that build barriers, they will always be representing themselves. And the persons with disability will always be in the outskirts. And we create policies because you mandate us. We create legal instruments because we mandate us. And you are the ones who implement them. And we test them through your implementation. And we don't implement, we facilitate the implementations. We provide political and policy guidance. That is our mandate, and that's where it ends. And we are always told at the national level is us who implement. But people who implement have to be empowered. They have to be aware. Because if you are not aware, regardless of whether you call yourself a human rights lawyer, if you are not aware of certain groups, forget it. You will still be a human rights lawyer according to how you define human rights, not according to how those people that you are pretend or you are claiming to represent, they look at human rights. Because to you, a human rights is the way you look at it. But if you don't get into this issue of a person with disability, I can tell you, you will still be coming here 20 years along the line, 50 years along the line, and 2063, still talking about the same thing. People with disability being discriminated, being poor, being ignorant, being beggars. And we have taken it as if it is a norm to see a person with a disability begging. That when they beg, when you see me begging, you will say, what happened? Didn't you go to school? But when I've got a disability, you say, you deserve it because you have got a disability. You can get 2 rand. And then you look to the heavens and you say, God, you saw me today, I gave.
Now we'll give 2 minutes or 3 to Honorable Malinga to address legal counsel to Parliament.
Thank you very much. I'm supposed to greet you. Oh, I only know 3 languages. All of them Zimbabwe. So I want to greet you in the name of the struggle of disabled people. I would have loved to tell you 1 or 2 stories about disabled people, but I was given only 2 minutes. Thank you very much.
Thank you very, very much. I think our session is ending in a note of a call for action, because what we have discussed would be dead if no action is taken. I remember a quote from Gandhi which says that the true measure of society is in the way in which it treats the most vulnerable of society, and persons with disability are part of those. And the call for action consists in us, legal counsel, being ambassadors, being proponents, being those who should take action to ensure that no one is left behind, to ensure that the laws that are passed by our parliament or through our parliament, depending on the situation that we find ourselves in, are at least consonant with the needs and the aspirations of the most vulnerable of our society, particularly persons with disability. I will thank the Africa Disability Alliance, particularly Mr. Dube, for the support given for this colloquium to take place. I will thank all presenters, Honorable Malinga, Lefoko, Dr. Thomas, and Madam Risa, for your insightful presentations. And I'll also thank colleagues for your attention, but particularly for your feedback to the presentations. Thank you very much, and we may also give ourselves a round of applause. So I'll leave the podium for the next session chair.
Let's give them another round of applause as they, thank you. As our next session chair comes, our presenter is already here, so we're just proceeding.
Good morning, once again. Good morning. Bonjour. Comment ça va? Habari asubuhi. Let me take this opportunity first to invite the presenter for my session, Advocate Lindiwe Michelle Maseko, to come ahead. Thank you very much. As you can see on the program, which was meant to be a session for today morning, the session is on the rules of engagement, avoiding the collision course between legal counsel and politicians in the legislature. When I saw the topic, an incident that occurred back at home 1 month ago flashed through my mind. I think it was very, very unprecedented. And what was the incident? The liaison committee of Kenya National Assembly, the liaison committee, which is a committee of chairpersons of all committees of a house, passed a resolution barring a member of staff of Kenya National Assembly from clerking. One of our staff members, a clerk to one of the committees, the members sat down, they passed a resolution, and they named him in person and said, this particular officer should never, never clerk any of our committees. Yeah. Interesting, but it happened last month. Yeah. I don't know whether that is a cause for dismissal for the officer. They didn't give him a right to be heard, but the members cited several reasons, very interesting reasons. One of the chairpersons says, this officer called me my darling. Yeah. Yes. So some of them said the officer failed to provide for transport for them when they are out on official business. Yeah. Others said he failed to pay their allowances. So many accusations. But what troubled us as part of administration is, what do you do with that resolution? What do you do to the officer in the light of that resolution? Anyway, I'm not a presenter. We are lucky today as we dwell into this area of conflict between the technical staff and the members. We are very lucky today to have with us someone who has really, really worked in this area. She had a very, very long biography, but I'll try and shorten it. I hope I capture all the key highlights. And this is Advocate Lindiwe Michelle Maseko. She was first elected as a member of a Gauteng provincial legislature in 1994, and she served in that legislature for 4 terms, totaling a total of 20 years. That is between 1994 and 2014. The hallmarks of that service was when in 2004, when she was re-elected for her 3rd term, she was also elected the chairperson of committees, where she was tasked with monitoring and ensuring performance of committees, which were the nerve centers of provincial legislature. I think maybe she will tell us whether she also passed a resolution on an officer or not. In 2009, she was re-elected for a 4th term, and that was now the highlight. And she became the first woman speaker of the Gauteng provincial legislature. Under her control, she oversaw the provincial government's service delivery to the population of Gauteng. She was also appointed the chairperson and champion of a sector oversight model by the National Speakers Forum of South Africa. Later on, she moved on in 2009 when she was now elected as the ANC National Executive Committee member, and then she moved now to the National Legislature. That was in 2004 when she was elected as a member of the National Assembly of the Republic of South Africa in May 2014, making her 5th term as a public representative. So in total, she has served 25 years in the parliamentary sector, 20 years in the Gauteng Provincial Legislature, and 5 years in the National Assembly. There's a wide range of experience in international work. The CPAs, she's been part of a resource persons, both for the Secretariat at regional and international level. In July 2012, she was elected the first woman chairperson of the CPA Africa region. And I think my first encounter with her, maybe she may not remember, was in London when I was accompanying our speaker, Muturi, some time back, when we were trying to lobby to replace her. She may not remember, but I do. So she was re-elected as the chairperson of CPA for the second year, for the second 3-year term between 2015 and 2018. In terms of, the CV is very long, I'm jumping some pages. In terms of academic expertise, she obtained an honors degree in leadership and governance from Wood School of Governance in 2006. She also has an LLB from UNISA in 2018. She has an advanced postgraduate degree in policy development and leadership and governance from WITS 2016, and a host of many other diplomas and certificates, which I think I don't need to go into. Community involvement as a whole wealth of positions, a trustee of quite a number of bodies, including the Soweto Heritage Trust, as a founder member of a trust of Bombani Home for Abused Women and Children, a trustee of Women and Men Against Women and Child Abuse, a whole host of history of travel around the world. So it is my pleasure to introduce to you our next speaker, and I hope she adequately addresses this burning issue for all of us of how we relate with our, basically our employer and the person we seek to capacitate, the Member of Parliament. Welcome. I don't know why she likes being called advocate instead of honorable. Advocate Lindiwe. Welcome.
Thank you very much, Chairperson, and good morning to everybody. Thank you very much for, it's a pleasure for being invited here. I was telling Zura that I'm also preparing, I'm going to Cuba this evening. But it's a pleasure that it didn't clash with this invitation to be here. And up front, I would like to also thank the previous panel that was here. It was very interesting, thought-provoking, and eye-opening. Just to start with, I'm surprised about the position of the committee to bar the clerk from attending and taking a resolution, because in my understanding, committees make recommendations, and the resolutions are made by the House. So I don't know how they took a resolution. They could recommend, but it's the whole House that consider that recommendation, and then if it's adopted by the whole House, then becomes the resolution of the House, which also becomes a responsibility of the Speaker to ensure that it is implemented if it is the right thing to do, but I think it is an unfair process that they took based on their individual personal accusations also. But you don't know the other side. So as a lawyer, the first thing you must hear the other side. So probably the other side was heard, and probably the facts were true. We don't know. But it's something that needs to be considered. But coming back to also the role of the parliamentary legal advisor in the current epoch, looking at the rules of engagement. I think traditionally, a legal advisor's responsibilities comprises providing legal assistance, creating legal documents, and advising clients or the organization or parliament on all relevant legal issues. I think some of the things is things that you know, things that you do as legal advisors, but probably sometimes it is important to just remind ourselves of the responsibilities that are ahead of us. The legal advisor is also, among others, accountable for taking the day-to-day legal responsibilities and providing legal advice that includes all the aspects of analysis, investigation, and drafting process. He or she is responsible for providing support in discrete legal issues by advising the institution, or parliament, or legislature, drafting, undertaking, and structuring remedies for the relevant issues. Chief among the responsibilities that need to be assiduously handled by the legal profession are, among others, to conduct legal analysis and research on various legal matters which affect the institution, provide advice on different legal issues, and assist in drafting legal opinions, memoranda, and other briefing documents. Also, be actively involved in drafting different acts and legal submissions, and conduct legal research by utilizing various resources and selecting the relevant material to analyze the legal information. I think in the previous panel, the issue of resources, adequate resources, also came up, which is an important aspect for a legal advisor also to be able to operate efficiently. Also assist in reviewing the legal material and any other relevant document, and to identify the most important issues that need to be sorted out on a priority basis, and to draw up formalities regarding the settlement of disputes and monitor the implementation thereof. Thus, the legal advisor is primarily responsible for providing high quality advice to the organization, parliament, or legislatures on major legal issues and problems. She or he is responsible for formulating the best possible legal solutions after analyzing the legal problems in depth. The legal advisor should be able to provide the much needed legal assistance while dealing with some particular legal tasks, litigations, contracts, disputes, dispute resolution, and advise the client, being parliament in this instance, on making a legally sound decision. Also advises on whether all the processes of parliament are in compliance with the requirements of all the relevant suite of legislation that is applicable to the institution. It advises the institution so that there is minimum legal exposure and liability. However, due to the dynamics of political neutrality and the special role which legal advisors play in a parliamentary context, the below roles that I've mentioned have emerged as important. Is a legal advisor as counsel to parliament, which also include traditional role of legal advisors as spelled out above as I've mentioned. The legal advisor is as a conscience for parliament with regards to the constitution, that the legal advisor offers opinions on the wisdom and constitutionality of proposed parliamentary actions, As one legal advice scholar once put it, that to speak law to power. In this role, the legal advisor must serve not only as a source of black letter advice to these clients, but more fundamentally as a source of good judgment. That means that one of the most important roles of a legal advisor is to advise the Secretary to Parliament or clerk in some jurisdiction as it's known. The South African context, we call them secretaries to Parliament, when a policy option is being proposed and is lawful but awful. As Herman Flegger, one former legal advisor, put it, you should never say no to your client when the law and your conscience says yes, but you should never, ever say yes when your law and conscience says no. Also, the legal advisor as a defender of the Constitution, this primarily denotes that legal advisors should, at all times, when preferring legal advice, take their cue from the Constitution. This is premised on Section 2 of the Constitution of the Republic, which directs that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligation imposed by it must be fulfilled. The legal advisor must also act as a spokesperson for Parliament about why the Constitution matters. Many people do not understand why obeying their Constitution is both right and smart, and that is the message that our Parliament and us as legal advisors must be committed to spearhead. At some stage in Gauteng, when I was speaker, we also had a forum that we started on citizen responsibility campaign and interacted with a constitutional court and in ensuring that as Parliament, we have the responsibility of informing the citizens, especially on their responsibility in upholding the Constitution. So what can be expected of the client, which is the Speaker, the Secretary to Parliament, committee chairs, etc., and what can be expected by the clients? Legal advisors expect their client to be attuned to the reality that legal advisors must carry out their duties and responsibility without fear, favor, or prejudice. In addition, the above-mentioned clients, those speakers, Secretary to Parliament committees, and so forth, must be well steeped on the centrality of constitutionalism in order to fully comprehend the legal advisor's role. As a corollary, these clients must ingrain in their minds that the ultimate boss of a legal advisor is none other than the Constitution, which Parliament as an institution must always take cue from in conducting its business. In turn, the legal advisor has the task of providing objective, reliable legal advice and legislative drafting services to Parliament. So how do legal advisors serve their clients better? In order for these respective clients to be served better, no predetermined outcome must be expected by the client. There should be no holy cows when legal advisors are dissenting the internal logic of their clients' briefs. In addition, there should be no rank bullying tactics in the process of inquiring as to how legal advisors arrived at their conclusion in furnishing advice to their respective clients. The autonomy of the domain in which legal advisors make their judgment must be sacrosanct. Legal advisors must be given carte blanche by Parliament to do their work, subject only to the dictates of the Constitution. However, in doing their work, legal advisors should neither be expected to usurp the role nor substitute the responsibilities of their clients. Management decisions still remain management decisions and fall outside the province of legal advisors. Nonetheless, in complex or politically sensitive matters, legal advisors who must ensure that they remain politically neutral must provide option where this is possible and marshal their clients to take legally sound decision in order to minimize the institution's legal exposure and liability. How do we then maintain integrity in instances where there is a conflict and or ethical dilemmas? Where I refer to the South African Constitution, I assume that other constitutions have some similar provisions. Section 1951A of the Constitution of the Republic of South Africa directs that public administration must be governed by the democratic values and principles enshrined in the Constitution, and a high standard of professional ethics must be promoted and maintained. This warrants that in conducting their craft, a legal advisor must be anchored in the virtues of honesty and integrity. Legal advisors as officers are also officers of the court, and they do not divest themselves of this character when they cease assuming the role of practicing attorneys or advocates. Or on the other hand, the section 195(1)(c) of the Constitution of the Republic provides that public administration must be development orientated. This means that legal advisors have to be knowledgeable about the intricacies of the political landscape in which they operate in, and not relegate its significance to the whims of their individual ideological orientation. This includes striking a balancing act between an understanding of the politics of the day without veering off from the high standard of professional ethics. Simply put, legal advisors are not prohibited from providing the necessary professional support to the vision of the administration of the day, provided that doing so does not fall foul of acceptance, a legal prescript of and the Constitution. Ultimately, legal advisors must accept that they provide the advice, and the client has the option of accepting or rejecting the opinion. This does not necessarily reflect on the content of the advice, but often may involve political strategy and policy. Legal advisors should therefore accept that often it is better to depersonalize the option and even encourage a second external opinion where the situation dictates. It's also important that I found it much important for legal advisors of Parliament to also work with state law advisors and other stakeholders, especially when you're dealing with bills. It becomes easier for you as a chairperson, and it makes the process transparent, faster, because you have the parliamentary legal advisor here, you have the state law advisor, you have also, you bring in the legal advice from the department itself to work together and take the issues that have been raised by the committee or the critique on the bill from the committee, go back and also advise the committee during the process of engagement, but also go back and rework on the issues that have been raised and proposed by the committee, which in most instances they are laypersons' issues, but they must have that legal connotation. But it is then that team, if it works together, that brings better results. Because I would ask, what do you say, Parliament? They have their own interpretation. What do you say, state law advisor? They bring their own, or they agree, and the department also. I think at that point the department want everything. They will give the context on how they arrived on a particular issue to be put on a particular bill, especially talking about bills that come from the department or from the minister rather than those that are private members' bills. There are also some occasions where principals or committee chairpersons or the speaker propose an external opinion for the sake of protecting the institution from backlash. And this should not be seen as reflecting on the legal counsel. This because of second opinion is also always welcome. There are, however, litigation challenges and best practices with regards to judicial cases against Parliament. Sometimes you do find that the legal advisors are sleeping on the job and they are not scrutinizing the documents and the issue at hand that they need to give advice, and they might give ill advice. So, but also as a principal, as a client, the speaker or the chairperson of the committee, you must not take everything at face value, you must also engage. So it means as the speaker, the parliament, the committees, you must also read and do your part so that when we deal with those rules of engagement and at that point, you also have your own facts and not only depend on what you are told without also interrogating that. So it is important also to equip yourself and be ready. Can ask questions when you're there, but it is important to be knowledgeable, even as a lay person on the issue at hand. But it is also important and it's necessary for legal advisors to be proactive, not wait until the matter is raised by the committee for them to go and do research. They need to be proactive and advise the client accordingly. With regard to the media being present in the context of openness and transparency and the challenges and benefits of that partnership, is that the media is a necessary safeguard of our constitutional democracy. This finds expression in section 16(1)(a), subsection 1(a) of the Constitution of the Republic, in which it is mentioned that everyone has the right to freedom of expression, which includes freedom of the press and other media. In the developed world and in more established democracies, the media is referred to as the fourth estate. The other three being the executive, the legislature, and the judiciary. The media is the mirror which our institution, including Parliament, have to use to measure their conduct in implementing the democratic project. The media is a necessary check and balance in limiting the excesses and the abuse of state power by other arms of the state, particularly the executive arm of the state and or Parliament. The media also plays a seminal role in disseminating information to the general populace. This also assists in fostering the principle of accountability by those who are entrusted with state power. So it plays a very important role, especially in oversight. So it is an important tool also to measure our democracy and also to involve. This is another critical safety valve in curbing the propensity of unrestrained behavior of the state. This really brings into sharp focus the caution that a legal advisor must apply in a language and representation of legal and presentation of legal advice. Because sometimes you have to advise, there are issues that still need to be discussed and dissected before they can allow the media to come in. Issues of the state security, because sometimes the media can be excited, and just blow issues out of proportion and report issues that are still being processed. But then also that aspect must not be abused by the principals or the committees or whatever committees there, because also with disallowing the media to be part of that democratic process will also be shutting them down, and it also affects our democracy, and I think it's something that we do not like. However, as we know, like any other right, the right to freedom of expression will be limited Example of is instances where confidential information warrants protection, where the security of the state is at stake, as I've mentioned before. So that's where you prohibit the media to be part of that formal processes that we're talking about. Overall, the professional relationship between Parliament as an institution and tribune of the people and the media needs to be jealously guarded. In advising on the limited instances where a meeting may be closed, the legal advisor must make very sure that the basis can be justifiably defended for excluding the media from the meeting. This relationship with the media must not only be protected, it must be nurtured and engendered. When this is achieved, we won't have so much suspicion when meetings are justifiably closed to the media. So on the needs and the role of the speaker, for instance, in our South African context, this includes also the chairperson of the National Council of Provinces, which is referred in other jurisdictions as the president of the Senate. In the Republic, we decided that there's one president, so you can't have a president of the Republic and a president of the Senate. So, and also the queue on having the National Council of Provinces, it's an example that we took from Namibia. They have the National Council. We have National Council of Provinces, which is a representation of provinces. The Speaker is the chief officer and the highest authority in Parliament and must remain politically impartial at all times. In other jurisdictions, on election, the new Speaker resigned from their political party. This is aimed at ensuring that the political impartiality of the Speaker's office is guaranteed. As the chosen representative and the embodiment of the House's authority, the Speaker ought to be impartial and make decisions that are in the best interest of the House as a whole. Ultimately, the Speaker is the guardian of the rights and privileges of the House and should play a leading role in ensuring that they are upheld, and in advising the Speaker, the principle must be uppermost. So including the responsibility of the Speaker of taking care and be responsible for the resolutions of the House. What I used to do with Nati here, is immediately the House met, we take a resolution from the recommendation. They immediately write, they have to put it in a letter form, and as soon as the same day or the next day, we send letters to all those MECs, provincial ministers, on what resolution were taken in relation to your department. And it worked very well. And we also had a tracking mechanism to ensure that the resolution also, it's not only those that want to debar the clerk that are being implemented and taken fully responsibility of, and others are put aside and put under the carpet and forgotten. And also then it becomes the responsibility of the committee itself. That in my, also as the chair of chairs we used to do, the committee must have as a standard agenda item the resolutions tracking, so that they know which of what, where, at what point is the resolution that they've taken in the House. So some of the functions of the Speaker as the leader of the House: the Speaker is the political head and serves as the executive authority, presides over debates. As a political head, in the context of South Africa, we're still arguing that the Speaker is not treated fairly and equally as the other heads of the other arms of the state. President, when the president leaves. But I also saw that in other countries and other jurisdictions, there is some in the rules or in the constitution that takes care of the speaker. we in South Africa, we are still fighting that, because when the president retires, he's got lifetime benefits. When the Chief Justice retires, they've got lifetime benefits, security, house, cars, secretary, and all that. But the Speaker doesn't have those things. And my argument in my other masters that I'm dealing with vets is on the efficacy of oversight, is on to what extent do we then regard the three arms as equal, interrelated and interdependent when the one, which I believe is the most important, the Parliament, because without Parliament you can't pass the budget. So if the budget is not passed, the executive can't function. And if there are not laws passed by the Parliament, the judiciary also won't have much to do in referring and relating to the laws and the acts of the country. So that arm of the state is actually supposed to be the most important, supposed to be taken very seriously. But it was interesting as a speaker of Gauteng, when once I asked, there was a law that was passed, so the executive was as if this law doesn't exist. So I asked the MEC of Finance, so I said, MEC, when are we meeting to discuss the budget, the allocation to Parliament? So he says, no, you must come and kneel down like all other departments, other MECs. He said, I'm not a department, I'm the legislature. I pass laws, you come to me, negotiate with me, and if I'm satisfied, then we can negotiate how you pay. But this is what we want to do. But it was also with the help of the legal advice. When we asked for research, we went out and proved that from 1994, each time Parliament presents its budget, the executive, the treasurer decides on some formula, or some, I don't know what scientific measurement they used to allocate 0.04 to Parliament. It doesn't matter how much you wanted, you just given that. Until we had the Financial Management of Parliament and Legislature Act that says that Parliament can take the top slice and the departments will see to finish, because they misappropriate the funds, and the easiest, the poor child or poor, even stepchild are treated better. The poor child that is abused, that will be taken from, is Parliament. If there's cost cutting measures, it's Parliament that is expected to do that, while the departments are not doing that. If they overspend, Parliament's allocation must go and help. We said, no, it can't work like that. If you are irresponsible, if you misbehave, then see to finish. But we also need our own, which is also important, because we had to get full resources to ensure that we capacitate committees, because if committees are not capacitated, if the committees also are not independent, we have independent researchers and advisors, legal advisor and so forth, we will always depend on the department, and they will show us what they want us to see, and will not get to the bottom of the problems that are there in our community. So the Speaker presides over the debate, has the final authority in enforcing and interpreting the rules of the House, and decides on matters of order, delivers rulings, and maintains order and decorum. In the South African national context, when a situation arises that is not covered by the rules, the Speaker may also, in terms of Rule 2.1 of the National Assembly, give a ruling or frame a rule in respect of any eventuality for which these rules do not provide. This should be based on applicable precedents. The functions of the Speaker are to be carried out with a view of doing what is fair for all members of the House, and to elevate the House as an institution In this regard, the legal advisor or procedural advisor becomes critical in protecting and advising the speaker in a manner that ensures and demonstrates impartiality. Sometimes it depends only on how the advice is presented or packaged. But also as the speaker, that's why I was saying it is important to read and refer to Erskine May, to other parliamentary rulings. When there's an issue, look at what was precedent within your legislature, your parliament, around the country, in the region, the continent, and also at international level. There was an instance where an MEC, the provincial minister, had some remarks, and on the point of order that was raised, but because you said it in Zulu, so those who raised the points had some few and not all, or did not understand the full context. I think also the translation was not very clear on what the MEC said. But because I also studied Zulu, while I'm Swazi, but I'm Zulu, I knew exactly what you were saying and what it means to the member of the opposition that she was referring that to. We sat with the legal advisors, looked at all the issues. We looked at precedent, and the final verdict was that there was something that we got from Erskine May, and there's something from the Parliament of Zambia that we brought in, and I had to ask the MEC to apologize, to withdraw and apologize to the member. And she was, for some time, she was not talking to me. Says, but that was not the point of order. I said, but that's what I heard. And in maintaining the decorum, somebody else will speak in a vernacular that is not understood by others and do those things. So it is important then also to look at those issues, some precedents, in ensuring that you maintain the decorum of the House and protect everybody fairly. Hence, the Speaker has to be impartial. The functions of the Speaker are to be carried out with a view of doing what is fair for all members, and the Speaker has to ensure that the House performs its functions, conducts proceedings, and order the decorum in order to alleviate the caliber of debates and preserve the dignity of the House and all of its members. The Speaker is, through the advice of the legal advisor, guided by the Constitution, rules of the House, as well as the power, privileges, immunities of Parliament and Provincial Legislatures Act, in ruling conduct, in regulating conduct and freedom of speech and debates in the House. In the South African context, the rules guarantees that members enjoy an unqualified right to freedom of speech in Parliament. The Speaker has to ensure that this right should be fully protected. Rules also prohibit the use of offensive and unbecoming language, with the example I've just made. This, however, should not be used to silence dissent. The legal advisor assists in ensuring that there is a balance and consistency in interpreting these rules. When it appears that the rights and privileges of the House and its members have been infringed, as the guardian of these rights and privileges, the Speaker should take the necessary step to ensure their protection. This is essential as it guards the authority, independence, and the dignity of the House and all of its members. In conclusion, at first glance, the importance of the Speaker may appear limited, but the Speaker plays an essential role in ensuring a vibrant and healthy parliamentary democracy. Impartiality of the Speaker is a key requirement and is deeply entrenched in parliamentary democracy. Although the Speaker is not required to give up party membership, the Speaker is required to act and be seen to act impartially at all times. This places a big responsibility on the advisor, as he or she must have regard for the tenuous position that the Speaker is in. In other words, often political awareness, but not involvement, is crucial. At all times, we, as legal advisors, must ensure that we not only put them in a position to deal with a legal challenge, but also that we do not hinder them from effectively pursuing the role as a Speaker of the House. Lastly, I think we can conclude by saying the role of legal advisors is very important. Just as the speaker is supposed to be impartial, so as the political advisor needs to be impartial, so that then they are objective and not subjective in executing their job and also giving the legal advice. Sometimes bills are returned based on the fact that the client disregards the legal advice that has been given. And it's also a sore point that you find that in litigation, Parliament loses their cases because of the poor legal advice. So in being a legal advice also, it's not more about money that you will get out of advising, but passion must also be there, and patriotism must also be there. It doesn't matter who is the ruling party of the day, but as legal advice, legal advisors, we have to be impartial, we have to be objective, and ensure that we give the legal advice that is expected of us. So I think, but also I think it is important also to apologize to those legal advisors, because as a legal advisor, you find sometimes that you can't answer back to the principals, to the politicians. You are too scared. Sometimes they insult you, but let it be water on the back of a duck, and continue doing what is right, as long as you know that the Constitution is your anchor and what you have advised is constitutionally correct, and you never say yes to a legal issue that needs you to say no. So stand your ground and give the advice that is needed. But it is also important to have a partnership and a relationship with especially the speaker or any of the presiding. I had a very good relationship with the legal advice. So if there's a matter that we have to be in the office until 2 a.m., they looked forward to it because we had a good relationship. And one thing that made me to also study law, Nati can tell you, that it was that in some arguments, I used to win those arguments. So I said, also, this thing is easy, I can do it. And the legal advisors are advising me, and I'm saying, but why can't we do this? They say it can't be done. I said, but why can't we manipulate this may? It says may. So if we can manipulate, and at the end, something happens where to admit a member. And it happened, but now the problem is that we can't pay because it's late in the evening. I said, phone that person, tell them that first thing in the morning, we're transmitting tonight. And that person must come, is invited by the speaker, who's from the government printing. So he'll be the guest of the speaker. So you get the gazette. First thing in the morning, 7 o'clock, we got it. And that's how I ended up studying law. And they can also tell you that I never allowed them to do my assignments. No. I would call them, put everything here and discuss it. They must tell me, because I was raw, and didn't understand, to make me understand, and then how I should approach it. So thank you, Nati, for those long nights that we had, sometimes leaving the office at 2, but working and ensuring that I understand what I'm supposed to put down there. So thank you very much once again for the invitation. Thank you very much. I remember that you thought you wanted to unseat me, but on the other side, I was working on ensuring that the speaker, Muturi, succeeds me. And he still consults me up to this day. Thank you very much. 。  . 。  . 。 . 。 . 。 . 。 . 。 . 。 . 。 . 。 . 。 . 。 。 . 。 。 . 。 . 。 . 。 。 . 。 。 . 。 。 . 。
. . 。 . 。 . 。 . .
Thank you very much.
Yeah, thank you very much, Honorable Advocate Maseko. I think that round of applause needs to be repeated and repeated properly. I must admit, listening to her, it tickled me to the core of my conscience because she was describing us from the other end. I don't know whether you got the same feeling that I got of the gravity of a position you hold in the legislature. Yeah. Here was somebody who was speaking to you from the other side. Yeah. And the gravity, it gave me a feeling that the legislature is about the law, about the lawyer. Both of us were my colleagues. But some of the things she said, really, I wouldn't link them. The Nairobi principles, professionalism, all those things. But the one that was touched me most was a challenge. She threw a challenge even to the colloquium. The role of a lawyer, the legal counsel, as it relates to the media. The role of a lawyer as relates to the budgetary process. You know, the speaker talks about capacitation. I recall even back at home in Kenya, our speaker, luckily for him, we passed a law that gave him benefits in retirement. And even I think now we are at the level where the deputy speaker is trying to get the same. And my recollection, it was all to do with the lawyers in the House, that achievement was gotten. We drafted the bill ourselves. We kept on fighting back and forth until finally it passed. Now we are fighting implementation. Our chief finance officer is, it's implementation that we are fighting. The executive is refusing to release the money. But it was all the lawyer. Yeah. Our role, media, budgetary process, and the integrity, the way we are integrated with the office of a speaker. You heard from her mouth. Yeah. For me, it was touching. It was a touching revelation of the gravity of the positions that we hold as legal counsel. If you sleep on the job, the legislature sleeps. Yeah. If you are up, the legislature is up. I think we must thank you for that candid revelation. Of course, I always say, always remember one thing about a person. I think the one we should remember most about her is never say yes when the Constitution and the contract says no. And never say no when the Constitution and the contract says. I think that can stick in our minds as part of the 13th declaration of this colloquium. Anyway, let's open the floor for questions. I begin with the, I think on my, I can see on my left side, we have 1, 2, how many? 3, 4. We have 4 on the left side. Beginning with the right at the back.
Okay, thank you. I would like to make some observations, actually, but I would like to speak in French. I don't know if Advocate Lindiwe will be able to listen.
Testing 1, 2, 3. English. Can you hear the English? English on channel 1.
Okay, merci beaucoup.
Thank you very much. I would like to thank the Honourable Advocate for the very technical and thorough presentation. We would have hoped that you could have continued for much longer because you gave us so much food for thought. In terms of the functions of the legal advisors, I imagine that it's quite sensitive, and it's something that can work in a state where the democratic system functions well, or at least seems to function well, because even if you have a legal advisor with all the virtues that you describe, impartiality, honesty, integrity, regardless of all of these qualities, it can be difficult for this person to fulfill those functions and fulfill his work, do his work in a state where democracy does not reign, or where democracy does not reign in practice. So if we were to consider today one of the aspects that you brought up about parliamentary majority, so if that parliamentary majority has a specific goal or a specific way of thinking or voting, in a situation like what I've just described, perhaps that is going to influence the legal advisor. And we have seen certain cases where the Speaker of the National Assembly has a whole cabinet or bevy of legal advisors, and the Speaker behaves like the boss of the legal advisors. And so what the legal advisors land up doing is they land up following the will of the Speaker of the National Assembly. And many of the legal advisors who are present here today actually experience this kind of situation in their national parliaments, and sometimes they don't have a choice because their own personal safety and security could be threatened. And so sometimes they are forced to accept what the Speaker dictates them to do, or what the majority in the House expects them to do. So I would like your opinion on this, and thank you once again for your very inspirational speech.
Thank you. There's a hand up there. Yes.
Well, thank you very much. I would like to thank the presenter, Advocate Lindwe, for the presentation that was on point. Mine would be an addition to what my colleague has submitted. Never say yes to a legal issue that deserves a no response. How possible is that? I'll speak from our jurisdiction point of view, Zambia, where you have the Speaker as a retired Superior Court judge. You have the clerk, who is a senior member of the bar, the deputy clerk, senior member of the bar. And we note that these are principal officers. Sometimes they want you to make an opinion that is politically right, and you don't believe in that opinion. So we've made it a practice with my legal advisors that sometimes we have to make two legal opinions. The one that we think is right, we file it in our separate files, and present the one which the principals want on one hand. So I want you to comment on that one. Thank you.
Very well, Uganda.
Thank you. I would like to talk about the media. You highlight the media as partners, but what happens if the media loses its objectivity and does not offer balanced coverage to the House? And why I ask this is because we are battling a case that resulted out of that. We're in court over that. Now, regarding the benefits, where I come from, we've amended the law and provided for benefits for the Speaker and the Deputy Speaker, both when they leave office and when they die. So everything is in black and white. And in my view, that's a way of insulating the speakership from the dominance of the executive. Thank you.
Thank you very much. My name is Romeo Maastorp. I'm from the Western Cape Provincial Parliament. I'd like to share an experience and then maybe just some observations after that. A number of years ago, I was asked to do a legal opinion regarding a particular provincial bill. It pertained to the power of municipalities to be investigated or to investigate claims of corruption, fraud, and maladministration. At the time, the department who sponsored the bill also had their legal advisor make a presentation arguing that the bill should be passed, and my opinion was to the effect that it should not be passed, and I was concerned about issues of sovereignty of local sphere of government. Both of us, myself and the other legal advisor from the department, had to make presentations to the particular standing committee. It turned out that the committee had to vote whether to accept my opinion or the colleague's opinion. My colleague's opinion, arguing that provincials should be able to penetrate the veil and actually enter local government and investigate and monitor their activities, that was accepted. After the meeting, the chairperson of the committee said to me in confidence that he agrees with my opinion, but he had to follow his caucus position of his political party. Now, that's the background. I want to make the following observations. Legal advisors are beholden to the Constitution. They are trained professionals. Independence of thought comes naturally to them. So whether one should say yes when you should say no, or the other way around, is stating the obvious, because we are trained like that. Question: do members of parliament appreciate that dichotomy or that paradigm? I say they don't, or they don't appreciate it, because members of parliament are party political disciples, and often legal advisors are an irritation to them. What has not been mentioned, and I think it would be naive to discount or to be silent on the disproportionate power dynamic that exists in legislatures, in national assemblies, between officials and members of parliament. There's a disproportionate power dynamic between a vulnerable official and an all-powerful chief whip and an ego-driven chairperson. Legal advisors, this is my observation, are vulnerable and not particularly or sufficiently protected by the institution or by members who claim that they equally are driven and informed by the constitutional mandates. Legal advisors, they know their responsibilities. They don't need to be reminded of independence, of impartiality, etc. I submit members of parliament do not share that. They are party political disciples. Our national parliament was taken to the cleaners in the last parliamentary term. A number of times they were clouted left, right, and center. Why is that? That's not because of lack of quality legal advice. Indeed, it is because of lack of political will on the part of members to be oversight disciples. It is because of the lack of a presiding officer's lack of will to be the champion for oversight and to present Parliament as the champion on behalf of the people. But what happened? Oversight was diluted, party political agendas were promoted, legal advice was ignored. And then we say, legal advisors must be independent and give quality legal advice. Is that quality legal advice prepared to be accepted by the party political disciples? It is said that the speaker should be politically impartial. That is rhetorical, it is fanciful. When I was in Scotland, I was astonished to hear that the moment a speaker becomes speaker, he or she must resign from his or her party. Fantastic. That is the remotest prospect in this country, because we want a speaker to manage the caucus line. I am not naive or oblivious to the disproportionate power dynamic that exists between legal advisors, independent graduates, and party political disciples. Legal advisors were not voted into position. They studied themselves into position. Members should appreciate that. The question then, because the topic is how to avoid a collision cause. The question then, how should legal advisors be protected? That's my question. Because it's not fair, it's not proper that a legal advisor should feel vulnerable for giving independent legal advice as it is required. It's not fair. How do we institutionally protect that official? Then we don't have instances like happened in Kenya, where officials should feel vulnerable and exposed to threat and risk to their person.
Thank you very much. Because of time, do we take the last floor to this side? Remember, we are supposed to be in Constitutional Hill, I think. So I suggest to take all the questions and then, yes, please. On this side now, yes. I think, yes.
So good morning. Is it morning? My name is Tabang. I actually want, I want to say congratulations to Advocate Lindiwe Masego. I want to ask her this direct question, and this is, I hope is going to answer what my colleague from Western Cape has just raised. How did you get it right in Gauteng legislature, where you protected us as legal advisors, and you made those who were supposed to come and account to the legislature come, and also the committees to be effective in doing their oversight? Let me make this example for the benefit of us that are here. There's a committee of petitions in Gauteng legislature. And I remember one time the committee wrote and asked the former premier to come and account, and 2 executive mayors to come and account, one from Joburg and one from Kuruleni. Both three powerful people within Gauteng. And they said to the committee, "Are we not coming?" And the committee went to the speaker and said to the speaker, "Speaker, we want the 3. If they're not coming, we're going to summon them." And the speaker said, "Summon them, let them come." And just before ourselves know that you were wanting to draft the summons, they finally came to come and account. But what was more interesting and effective was that the speaker became independent and protecting legal services as it is. And also, in a lot of times you find when you start wanting to speak or you summon the former premier, someone very, very, very high, you would be told about you're going to embarrass an organization, or there's a caucus view, you must never do that. But my question would be, you stood there and said, I want to be independent and I'm going to protect legal advisors from Gauteng. And so my question would be, how do you deal with that? Thank you.
Thank you. I think that's enough for today. Unless if there's any other. The last one, the very last one.
Thank you very much. And I want to also join the others in thanking the presenter. My name is Dennis Kwirige from the East African Legislative Assembly. I want to agree, first of all, I make maybe two observations. I want to agree with my colleague from the Western Cape and associate myself with his views, most of them, and propose that probably the bigger problem in this is the lack of appreciation of the politicians of what we as lawyers and technical personnel do. And this, in my view, largely calls for further engagement with them. As you can see, in a meeting or a conference like this, we will be largely speaking to ourselves. We do the same thing, so we'll be sharing experiences. I propose that, in future engagements, we need to engage with more of the members, more of the leadership, chairpersons of committees, speakers and deputy speakers, so that they appreciate the dilemma in which we find ourselves most of the time. And to illustrate and add to what my colleague from the Western Cape was saying is, sometimes if you take that advice literally of saying that, if the law says no, you say no, the first thing that is going to happen to you is if you say no to a member, they are going to, the next thing is you'll receive either a call from a chairperson. If it's not a chairperson, it is a deputy chairperson, a deputy speaker. If it's not that, it is the speaker or the clerk themselves. And you see, the things escalate so quickly in such a way that you're exposed. And in some instances, it's people actually who really can also read and see the things in black and white, that this really is a no, this is a yes. My problem is really this. The politicians are slowly turning the lawyers into politicians as well, which is where the problem is. And because when you do that, then you also now start playing the politics. Because once I tell this member this, they are going to go here, so you either run there first and say, this is what is happening. So, and you see, that takes away from really what we are supposed to do. So my recommendation would be to call for, further engagement, especially with our clients, the members. And in my view, one of the ways that you need to catch this, this needs to be caught early. One of the ways is through induction. At the beginning of an assembly, when there's the new assembly, there has to be a lot of emphasis on the roles and then the understanding. It is true that whereas many of the lawyers, or most of them by training, appreciate their constitutional duty and their duty to the Constitution anyway, the members are politicians. So they will have a duty to the Constitution when it suits them, and they will dispute that duty or neglect it when it doesn't suit them. My worry is us following the trend of also becoming politicians in the process. I thank you.
Thank you very much. I think so you can see the ventilations. I remember one day we were told in the Congress, the American politician is not bound by the Constitution, but the staff are. Sorry, I'm saying I remember one time we were told in the Congress that the American politician is not bound by the Constitution, but the staff are. But you do it. Madam, please respond to.
Thank you very much, and thank you for the questions. Very interesting. It's true when you say that some of these issues work in democracies that are well-oiled. But you find sometimes the speaker acting as a boss or so. I wanted to link it because also it's almost the same as from Mamulamu here from Zambia. In Zambia, now that you are here, the issue that you raised, that you have two legal opinions, you present, there's one, the other one you keep, so it depends on the mood. You know, after the former president, Banda, was out of office, and Sata came in, I think 5 days after that, Banda's son wrote a whole full-page article, if you remember. He said, you know, my dad was a very good person. He had a whole lot of very good advisors around him. They advised him. He didn't want to listen, didn't take. So he had the other, he wanted to, he didn't take what they were telling him. So eventually, they started telling him what he wants to hear. That's why today he's out of power. So that also goes back to say, as a legal advisor, don't compromise your position. What is yes, say yes. What is no. Because being bully as a speaker actually doesn't help you. I believed in working in a collective. I was speaker, but I would consult whether younger than me by age or by political muscle. But if I believe that you know this subject better than me, I will call you and ask for an opinion and ask for an advice. So, and I think by doing that, you're not diminishing yourself or belittling yourself, you're actually growing. That is also going to what Tabang was asking. And what I established, I was fortunate to have in Gauteng to have served. There's a legislature service board. So as when I was deputy speaker and I became chair of chairs, I became chief whip, I was one of those people who would participate in that forum. And what was interesting is that especially when it's financials that are being discussed, we will be there until 2 a.m. The speaker will be asking questions just like us to the technical and the support staff. And when I became speaker, I thought it can't be right that as a speaker, you also ask the same question. So I established a speaker's, what did I call it? Speaker's Budget Council. And I said, we're going to meet, we're going to discuss all heads, all directors, senior management. We're going to meet, we're going to look at everything, we discuss it, and this is a boxing ring. So that when you go to the LSB, the Legal Service Board, I'll be on your side, I'll defend you. And if what I can't answer is what is technical, and I'll ask technical people to come in, but I'll be on your side. So when we went to the meeting, we had cleared everything, And maybe I'm sure we started at 10 and at 3 the meeting was over. Everybody couldn't be, how come is this meeting so? I said, because we did all the background work. I'm not asking questions like everybody, but I'm responding to questions that are being asked, that we have discussed, that I know why 1, 2, 3 is like that, in such a way that we even went to an extent of, it would go to an extent of the very directors reporting that, no, you said we must go back and cut on the budget. I know this one has not cut because of 1, 2, 3. So they were also even spying on each other, but for, positively so. That let us all cut if we have to cut. I was the first speaker to appear before the Public Accounts Committee, because I believe that in the Public Accounts Committee, that is where you find the truth, the whole truth. And I would advise also the MECs, I used to advise them that, go and just sit, not because you are responsible, you must answer questions, don't answer anything, just sit in that meeting. And that is where you will get the truth, because some of the things that the senior management in your department are not telling you, they will come in the Public Accounts Committee. And I found some who did well, and would say, well, when you go back, heads will roll. And I think it is something that is very important, that you stand your ground, be principled, and if you have to subpoena, if people don't want to come, you subpoena them. That's the law. You are covered by the Constitution, you are covered by the rules. So, because what happens sometimes is that when in South Africa, as you all know, that we were fresh from being activists, we didn't even have an idea, some of us, what is expected to govern. So when we wanted to do oversight, we used to ask for permission from the members of the executive. Can we please go and check this area? And by the time we get there, they've cleared everything, until it got to us that, no, but why are we asking permission? We must just go, because it's our responsibility. And that's when they saw that we mean business. But also it is true, to the colleague who spoke in French, that where also in Gauteng, the party was very strong. We made it clear that if a minister or a provincial minister, MEC, does not attend to the study groups, to the meetings, they don't come to the committee, we're not going to pass their budget. Very clear. We're not going to pass the budget. Your first responsibility is with the committee, so you must come there. So it also is up to the speaker to be principled, to stand their ground, and not to be shy that I will lose my job because I took this particular position and route. I'm proud that I'm still like that. I'm known for being that. So I don't have grays, there's black or white. If you take it or leave it, if you don't want, as long as, the one thing is that as long as I am legally and constitutionally right, I'll go with the matter. Remember in Gauteng at some stage, there was a time when they were saying they want to change. There's a chief whip of the majority party. And so they wanted to change it to chief whip of, it's my party. They wanted it to be changed to chief whip of the legislature. Said one thing that you must know, you'll be subjected to the speaker if you're chief whip of the legislature. You have an upper hand as a chief whip. And so far, according to the Gazette, it says chief whip of the majority party, not of the legislature. So until the judge, the commissioner of the Remuneration Commission changes that and is gazetted, I will not. If I have to be fired from this job, let it be. But I will not do thing that is against the law. And how do I justify it if I do that? So I think it is important to stand your ground, and that's what I did, Tabang, to stand my ground. Whether you remove me from the list, it's up to you. But I will not compromise my principles. I will not compromise my integrity for something that will be an egg on my face. The media, it is true that media, sometimes it loses its objectivity, because when we meet, what we used to do, and I used to do, I tried to meet with I used to have a meeting, a breakfast meeting with all ambassadors, so that when there's a trip and there's a problem or somebody has a problem, it's a phone call, because I believed in building relationships. So if you build a relationship with your legal advisors, with ambassadors, with whoever, then with the media houses also. So when we ask them, but we're doing this is right, and this is supposed to be, headlines and stuff, they say, but it's not juicy stuff. So we want things, the sensational issues, not the obvious. So that is why there's always that antagonistic relationship between ourselves and the media. Western Cape, I think we have an example of Advocate Vanara of Parliament, who never compromised, stood his ground. It didn't matter whether the minister said that, the deputy minister did 1, 2, 3. He reported what was correct. So I know the issues of oversight, diluted, having the party line, but we don't have to compromise our principles. For me, principles, integrity are the core. And tomorrow, even if you're not in parliament now, I'm trying to get into the legal space. I'm a trained diplomat. So I'm not begging anybody, because I'm marketable myself. And so if you're doing things so that because you're trying to protect your turf so that you are not fired, but then you are compromised, then I think it's the wrong field. I know that we are behind time, but thank you very much for all the questions. And it's true, yes, MPs sometimes do not appreciate, but when you give them the yes to and no, it's their fingers that will be bent. We have a Zondo Commission. It's because of some of those things that people did not want to listen to legal advice. They wanted to do what suited them, so they are now in the cookie jar. It's unfortunate, but thank you very much. It was a pleasure being here and spending time with you. Thank you.
Yeah, another round of applause, please. One of my political friends told me, thank you. One of my political friends told me that for you to be elected, if you want to be a politician, you never say no to your constituents. You always say, yes, I'll do. So when I went back to the office, I never say no to a politician. I always say, if you ask me, I don't tell you it's unconstitutional. I tell you, yes, let's amend that constitution. Yeah. You say yes, no, in a positive manner as a staff. You don't say no in a negative manner. When you say no in a negative manner, you become an enemy. But when you say no in a positive, you just rephrase it. Yeah. And then I think the politicians will be happy. Anyway, thank you very much. Another round of applause. Then I think I'll hand over the program to Mudomi. And we apologize because we had to catch up with yesterday. Thank you very much.
Thank you, Mr. Dubi. Delegates, we do apologize for the delay in the program. As I had the moderator mention, we're supposed to be in one place at this point. I now want to request that when we step out, let's quickly grab a cup of tea to replenish our energies. Then the buses are waiting for us outside. We need to get to the Constitution Hill where we are being waited. I'm told the buses could not be able to make a turn at the roundabout where we took the picture yesterday. So after you grab your cup of tea, we walk past the police point. Their buses are waiting for us outside there. Thank you so much.
Where's the